the matter of Amanda Huntemann versus Tina Hart. The file number is 252573LT. Amanda Huntemann is here from a vehicle somewhere, and Tina Hart is here at the conference room at the courthouse. We were here previously on December 19th. Ms. Huntemann has a agreement to sell this house. There's a purchaser waiting to purchase it. In order to sell it, she has to get the tenant at sufferance, Ms. Hart, out of the lower level. So we were here on December 19th. We discerned that there was no lease, no rent since September of 25. Notice to quit was filed some time ago. Ms. Hart indicated she didn't have a way to get out of there, and she didn't have anywhere to go, and was sort of stuck. Ms. Huntemann, however, is in a hurry to get this property vacated, or she may lose the potential sale of the property. Ms. Huntemann is here. You indicated Ms. Hart is still there.
Yes.
Ms. Hart, what's your position?
I have everything packed. I just need a couple more days to get it moved.
All right. The law says that you are to provide your forwarding address in writing and turn in the keys within 4 days of your moving. There is no lease, so there is no security deposit. So we're not probably going to have a security deposit issue. Ms. Huntemann, I'm sure you're not thrilled with this, but the defendant gets 10 days from today to move before she's subject to eviction. When does your purchase agreement expire?
31st.
January 1st, January 1st?
December 31st.
December 31st. So in order for this, you'd have to move by 2 days from now. I'm sorry this took so long. If your buyer can hold on. Ms. Hart, if you are out by December 31st, that would be great for all concerned. But the law says you get 10 days from today. Today is the 29th. That would give you until December 8th to vacate. If you're still there in January, you could be liable for an additional months of rent. There is no money judgment entered here. Is there any chance you could be out by the 31st?
A really good one. Again, I have to line up rides and stuff because I don't have a car of my own. But I will be able to give them, like, I have a PO box and stuff like that, so, but there were no keys.
There were, okay, no keys.
Yeah.
You have until January 8th, December 8th, January 8th. Hopefully this doesn't cost you a several $100,000 sales agreement. I don't have a better answer for this. I can't make her leave in 2 days. I can't jumpstart the law. Ms. Hart, you're not going to be gone by December 31st, but you can be reasonably assured that if you're not out by the 8th, they'll be there to evict you on the 9th.
Yeah.
They're all quite anxious about this. Do you have heat now?
Yes.
All right. You guys are stuck with each other for 10 more days. All right, Ms. Hart, you go out to the counter and they'll give you a copy of this. You have to be out by January 8th, 2026. Or you're going to be evicted probably the very next day. There's no keys and there's no security deposit, but they should have your forwarding address in writing, even if it is a PO box.
Okay.
All right, if you go out to the counter, they'll give you a copy of that order. Ms. Huntemann, how's it going otherwise?
Okay. I was going to mention a few things, but it seems like I'm not gonna get much of an option. So
I don't have the authority to simply give her 2 days to get out. And that's why I'm sorry it took so long to do this. Now, if there's money damages, for example, if you contend that she damaged the property, you could sue her for those money damages, but if your sale goes through, you won't own the property. Let's say the price was $500,000. And it's alleged that she did $10,000 worth of damage. So your purchaser says, I want a $10,000 off my sale price. You could sue her if it reduces your sale price.
Okay.
Theoretically, well, in district court, you can sue for up to $25,000. In small claims court, you can sue for up to $7,000. But we're stuck with this. The timing was terrible. She wants to move. She doesn't have the ability to just pick up and go. But you've been trying to get her to move since early October, and we're going to be into January before it happens. But hopefully she can get out, your sale will go through, and everybody will live happily ever after. Probably not. Ms. Hart, you go with out to the counter, and the clerk will give you a copy of that order. Ms. Huntemann, thank you. If you have any questions, just contact the clerks.
Okay.
Thank you. This case, this is Memory Lanes versus Mason. Stuart Weiner is here. Meg Bauer is in the background. Mary Ellen Mason is here, and Mr. Richard Pizzoli, the owner of this and another park, is here from Bloomfield Hills or thereabouts. We determined last time that through December rent was $2,300 and court costs were $286.20. Defendant had indicated her plan was to vacate. What's our current status, Ms. Mason?
I still plan on moving. I just have to get up a little bit more money, which will be like the next week and a half that I'll have the money to move.
All right. Yeah, there's always the issue of having someplace to move to.
I'll be moving to a hotel until I can get the money up to get another place.
Well, you have 10 days from today, which would be January the 8th to
Yep.
vacate. Mr. Weiner, if you'd send me an order for $2,300 through December, $256.20, and costs for a total of $2,556.20. The date for the writ would be January the 8th, which is a Thursday. Probably wouldn't actually issue till the 9th. Now, Miss Mason, when you move, you need to turn in your keys and give your forwarding address within 4 days of your moving. That triggers the security deposit law. If you don't move until January 8th or sometime after January 1st, theoretically another month's rent would be due. And so that would add another $750, I think, to the total. But at this point, your plan is to move. If you can move by the 8th, that would be great for you and for them. Turn in the keys, give your forwarding address. If we're going to fight about money damages, it would be at a future hearing where everybody would be under oath after you vacated. Do you have any questions?
No, I don't.
All right, Mr. Weiner, when you send me the order, I'll sign it.
I will. Your Honor, it may be a little later this week because we're now short-staffed, you know, in these last couple of days. But I'll get it to you as quickly as I can.
We'll do the best we can. All right, Miss Mason, best of luck to you.
Your
All
Honor,
right, thank you.
Your Honor, can I
Your
ask one question? And then Richard,
Yes.
I have the same question. I think she has a home that's on the property. I'm curious as to what Ms. Mason intends to do with respect to the home.
What do you mean a home?
You rent a home as well as a lot.
Yeah, so you get it back. She vacates. This is lot and trailers, not
That's
just
right.
lot. I thought. All right, so
I don't own the
Pizzola,
trailer.
what was your question?
Your Honor, my question was, is she in a position to offer payment of any type of rent if she's going to pay a hotel at this time?
I would guess
I've
the answer to that
offered
is
to, I
no.
asked Chris if I could make payments to catch things up, and Chris told me no.
All right,
So I
well, I
haven't put
can put
anything
you
toward
guys,
it
so you're
yet.
talking about paying rent to be able to stay there, Mr.
But
Pizzola?
Yes,
she-
Your Honor.
But
All
she
right, well,
gave
let me put the,
seven,
just a minute. Let me put you in a breakout room while we argue with Mr. Apps.
Thank you, Your Honor.
Go right to the top sometimes is the right answer to that. So Mr. Weiner, Mr. Pizzoli, and Ms. Mason, I'll put you in a breakout room and you can discuss perhaps something to maybe pay rent rather than a hotel and
Yes,
maintain your tenancy. So, all right, everybody hit the button that says join.
thank you.
Okay.
All right, this next matter is Darlene Fox versus Russell Sword. The file number is 252588LT. Mr. Gary Apps is here on behalf of Darlene Fox. She's here in the background, and Mr. Sword is at the courthouse at the conference room. Ms. Fox filed a termination of tenancy action. Wanted the defendant to move. He indicated that he was perhaps looking to move to Portage. Defendant filed some stuff. They didn't date stamp it. So I don't know what day it was filed.
I just found it. I'm getting out.
Defendant contains notice to quit to get property back doesn't match. I have a different court has this. Retaliatory eviction under MCL 600.5720. Harassing me, treating me at work, which caused me to get hurt. Been off work since August 15th on workman's comp. 3, unlawful interference, 600.2918. Took my tree stands and burnt my daughter's hunting hunts. Sheriff was there, I heard her say it. Pay back 3 times the amount. Malicious destruction of property, burning my daughter's hunting hunts. Counterclaim for statutory damages, request an adjournment. So we did do an adjournment from last time to this time. And we did note there was a supplemental complaint. Mr. Apps, what are the status here?
Well, Your Honor, this morning briefly, and he didn't mention any of those other documents you've cited, so this is kind of all new to me, but I did have the rent calculated through the end of December and through today, but as far as I know, he's still in possession of the property.
I just found a place today. Getting out.
Say that again, Mr. Sword?
I just found a place today, 2 hours before this meeting. I got a call, so I can be out of there by Sunday.
All right.
That was right at the last minute. I've been filling applications out, looking. I finally got the call back.
Don't tell me the address, but what town is it in?
It's gonna be in Three Rivers.
All right. Where does your daughter attend school?
She does online. Through,
All right, so she'll be able to continue with her high school.
I've already contacted them, told them what was going on, and they can keep going. She does it right there in Three Rivers, just links home.
All right, so that'll probably actually be more convenient. All right, the law says, Mr. Sword, that you get 10 days from today to vacate before they can ask for a writ of eviction.
I'll be out.
There is also, so that would be January the 8th. There is a complaint for supplemental money damages. Mr. Apps, Judge McManus's position, which I've carried on, is you get one bite at the apple. If we do the supplemental damages today, we won't yet be into January, and you won't have a chance to take stock and assess the condition of the premises. So what we normally would do is enter the money judgment, enter the possession judgment. After they vacate, you can file a hearing regarding supplemental damages, and then we can determine that. Is that agreeable with you?
Well, I've seen some courts that they'll defer the possession judgment based on the tenant's promise to move out. They'll then schedule essentially another hearing, 2 weeks, a month, whatever the calendar allows. I've had them go even 2 or 3 months, because once possession's been surrendered, the money judgment doesn't need to be addressed today. And possession obviously is the more important factor to my client. So a couple of ways to do it. One might be to set a new hearing dates after the 8th. He said he'll be out by this weekend.
You'll file the Landlord-Tenant Relationship Act, the security deposit notice. How much is rent? How much is utilities? How much is damage? How much is offset by the security deposit? So I will find the plaintiff has a right to recover the property on or after January 8th, 2026. We'll address that later.
Since we're all here now, if the court was able to determine a subsequent hearing date, then certainly Mr. Sword would know it, Ms. Fox would know it, and we could all plan to coming back to figure out if they're the supplemental complaint damages. Just a thought.
Well, that may be the way they do it in some places. I don't have the ability to wing it from the bench to put a date. Also, I don't know if it'll take 15 minutes or 3 hours. I don't know how contested it will be. I don't know.
Well, if our option would be to wrap it up today, take the supplemental complaint through today, have him out in by the 8th. I'm not sure how much of a deposit he has after 5 years, and I think my client would just as soon wrap it up. So if given the alternative, I just as soon wrap it up today. I can give you the amount of rent for possession through the end of December, the amount of rent through today, and just call it good.
All right, well, if he agrees with that, how much is rent through December?
Be $3,200, court cost of $271.60 for a total of $3471.60. I'm sorry, $3,200. $271.60. $3471.60. That's through the end of the month.
Is there
but this is a termination
deposit?
of tenancy, so technically there shouldn't be a possessory amount. So that you asked me the question, but there shouldn't be a possessory amount. This is a termination.
I understand. Is there a security deposit?
Ms. Fox would know. I don't know. I know she's there, but I don't know if she's listening.
Yes, I paid
Yes.
Yes.
Is there a security deposit?
Yes, it was $650, and there'll be a water bill due too.
That's the problem when you're in a yank to get to the finish line.
Well, I can forgo the water bill, but there was a security deposit. But there's going to be a lot of damages. It's a mess.
Yeah, so you think that just a minute. Mr. Weiner, you asked me to join this room. I'm gonna close the breakout rooms. All right, now we've got a cast of thousands on here. No, Mr. Epps, I don't have time to deal with this right now. It's disputed. There's a water bill. She said the place is gonna be trashed.
He promised me that in emails. I have emails from him saying, I'm going to trash it. I'm going to leave you a mess.
All right, then we'll just he's
But
got
that's up
till
to you.
January
That's up to
8th.
my attorney.
We'll address the money damages after he vacates and you take possession of the premises. All right. See red.
What do
Is
I
that
need
what
to
my
file
attorney
to get a
recommends?
second hearing? Just to press B for a second hearing?
Well, you need to file a supplemental complaint for money damages. You need to tell me how much money that you're claiming. How much is rent? How much is,
We'd be willing to go with the supplemental complaint we've got now, sir, and then let him give us a forwarding address. We'll address the security deposit after he gives us his forwarding address, and then we're done with the court.
no, we're not. He doesn't accept the amount that's due. There's a water bill we haven't addressed. She contends he's gonna trash the place. Let's say he does. You're stuck with the judgment you've got.
Place isn't trash.
So, this isn't all that complicated. We do it all the time. Once he vacates, you file a claim for supplemental money damages and say what it is. We'll have a hearing, we'll place people under oath, and we'll determine what the amount is. But right now, it's just a possession judgment. We will address the money damage issue, Ms. Fox, after you get the property back. If he has
I
trashed
just
it,
have
I
a
want you
question.
to,
I have a question. What about the past rent? I'm struggling. I mean, that's $3,200. I'm a widow, and that's really hard for me. He hasn't made one attempt to pay me a dime since September.
well, and he probably isn't gonna be in a big hurry to do that. Right now, he has to pay first month's rent, security deposit to get a place to move to.
Yeah,
You filed this as a term.
He bought a truck with my rent money.
Yes, and now he has to vacate. So we'll have a hearing. I can't just wave my magic wand and make him give you $3,200. Mr. Apps is in a yank to finish this today, and we're not in a position to do that. So Mr.
Okay, well,
Sword, you go out to
whatever
the,
you need to do.
all right, we'll have a hearing.
Whatever
I'll
you
let
need.
you, I'll let you testify as to what you believe he owes you. And then I would issue a money judgment that says he owes that. And you could seize assets or seize his wages. But we aren't in a position to do that today. So
Okay.
we'll have a hearing after he vacates. Again, if he's trashed things, you take a picture of it, save receipts on how much it costs to go to the dump or how much an estimate is to repair things. And we'll make a claim for
Okay.
that entire amount and we'll hear about it. But for now,
Okay.
you're good to go.
I took care
This
of
is
it.
under the same court case number, sir, correct?
Yes, correct, correct.
Okay. I'll figure it
All
out.
right. All right. The clerks will help you. We do them all the time. In fact, I thought everybody did it that way, but they don't. As you know, they do things differently and all over the state. Mr. Weiner can attest to that. I just try to do it the same way every time. All right, Mr. Apps, I'll see you next time. Mr. Sword, you go out to the counter and get a copy of this. You got till January 8th to move or you're subject to being evicted by the sheriff.
I'll be out.
All right, thank you. All right, we're gonna return to Memory Lanes versus Mason. Mr. Weiner and Mr. Pizzoli and Ms. Mason were in a breakout room. Did we make any progress?
We did, Your Honor. What we have agreed to do is enter into a consent judgment. The consent judgment provides for an amount that's currently due and owing of $2,676.20. And let me provide you with the background so that you have a record of it. She owes $2,250 in back rent, which covers the months of October, November, and December at $750 per month. She has late fees of $170, which consists of $20 for September and then $50 for October, November, and December. That total is then $2,420. And then we add the court costs of $256.20, which consists of a filing fee, attorney fees, and process server. And the total is $2,676.20. Now,
Mr. Landman, you may have heard that $50 late fee as of January 1. We'll let it go to 50, so we may have to alter some of your numbers, but for the mobile homes, I've been allowed it essentially here at the first of the year to go to 50. I know we had discussed 40.
I
Mr.
appreciate that
Retzlaff, don't we-
information, Your Honor. Thank you.
All right, anyway, Mr. Weiner, what's the consent portion of this?
so Ms. Mason is going to make a payment of $550 by Friday, January 2nd. She will make a second payment of $550 by January 9th. And then she will continue to make payments towards satisfying that judgment. And will work with Mr. Puzzoli to allow her to stay, so long as she is completely current by February 18th of 2025. If she is not completely current, and that current is $2,676.20. Now, she understands that another $750 is going to become due in January, and perhaps another $750 will become due in February, depending on her ability to get these funds. But she will remain in her mobile home until February 18th, 2025, if she is completely current. If she's not, we'll apply for a writ.
All right, and the date would be February 18th, 2026.
2026, yes.
All right, so that calls for a conditional order of dismissal based on those terms. Ms. Mason, did you hear everything that Mr. Weiner said?
Yes, I did.
And do you agree with those terms and conditions?
Yes, I do.
And do we have your authority to show here that you consented to those terms on the record?
Yes.
All right. Mr. Weiner, if you would send me a conditional order of dismissal on those terms. Mr. Puzzoli, thank you for stepping in here. That helps this lady try to keep her tenancy for a while, helps you keep a good tenant on the spot.
Thank you, Your
And,
Honor, for your guidance. Thank you.
Maybe she can get some emergency help.
We'll try to
see.
do what we can to work with her. She's agreed to make her weekly payments of $550 every Friday, and that will clear up her arrearage, and we look forward to working with her going forward. Have a happy tenant.
Thank
All
you.
right. Ms. Mason, do you have any questions?
No, I don't.
All right.
Merry
I'll
Christmas,
let you-
Ms. Mason. Thank you.
All right.
Merry Christmas to you.
Thank you.
All right, remove Miss Mason. All right. Mr. Landman, we're gonna finish our last memory lane case and then we'll go to our Centerville case. That would be 252597 Memory Lane Mobile Home Park versus Andrew Richlag. Mr. Richlag is here. Mr. Puzzoli, the owner, is here. We determined that through December, rent was $3,200, $256.20 in court costs for a total of $3,456.20. He indicated he had tried to get some assistance and was denied.
Your Honor,
Uh,
I did get a hold of the Hera group. They are calling me within the next week for assistance, and I have paid $450 in this last week.
And that's correct, Your Honor. Mr. Retschlag paid $350, and then recently, either today or over the weekend, he paid another 100. So he now owes a total of $3,006.20 is the current balance. And again, what I want to remind him of is he will owe on January 1, $875.
Yes, sir, I'm aware. And I will be sure to make that payment on time. I'm sorry for the delays.
Okay.
All right, well, it sounds like things may be happening. Now, let me tell you some things that you need to know. Just a minute, I've got a number of people that are waiting for small claims. I'm gonna bring them in. Oh, boy, they don't have names. We'll do the best we can once we get them in here. A number of people have just joined the feed, and they're here for small claims court. We'll be addressing those right now, but we're finishing up our landlord tenant docket. Mr. Weiner and Mr. Pizzoli and Mr. Redschlag. The attorneys know this. They don't have to evict you on January 8th. They have 56 days from today to ask for the writ and another 56 days to serve it. So they can agree to work with you to try to get caught up on the rent. But I'm going to give you a judgment which is going to say that you owe $2,676.20. Let me get this right. The rent was $2,250, 2250 minus $450 is, oops, $1,750 in rent, $170 in late fees, and
My numbers are a little different.
$256.20. Let me see. Wait a minute. That's not right. It was the other number, 2,300 through December. 2,300 minus 450 is 1,850. That's still not right.
No, I had 3,000.
No, wait a minute. I'm looking at Miss Mason's file. I'm looking at the wrong page here.
Oh, yes.
3,200 minus 450 is 2,750. We have $200 in late fees. That's not going to come out right. And 256.20. No,
You're close.
2,750 plus 256.20.
I can detail that in the judgment.
No, that gets the number. The rent is 2,750. Court costs are 256.20. So the total is what you quoted, $3,006.20.
Correct.
It's going to be due by January 8th.
Right.
And let me repeat, they don't have to evict you on January 8th. They have 56 days from today to ask for the writ of eviction. So I suggest that you stay in contact with Ms. Corpening when she gets back, or with Mr. Pizzoli, and let your funding source see this judgment that you're going to get in the mail that says you owe this much money. Now, Mr. Weiner also indicated on January 1st, you're gonna owe another month's rent of $875. So take that amount, it's gonna be close to $4,000 that you're gonna owe. So I'll send you the judgment. Mr. Weiner will send one to me and I will immediately send it to you.
We will do that, Your Honor.
All right, Mr. Reschlag, do you have any questions?
No, Your Honor, just making sure that I've gotten everything understood. I owe 3,006 as of this month. As of next month, it'll be about
Yes.
4,000.
That's
Yes.
correct.
All right.
All
I have
right,
no
good luck,
further
sir.
questions. Thank you.
All right, Mr. Weiner, that completes your obligations.
Thank you,
And
Your
I'll
Honor.
see you next time.
Thank you,
All
Your
right, Mr.
Honor.
Reschlag.
Have a happy new year, sir.
Legacy versus Marie Baugh. We were here previously. This was filed as a demand for non-payment of rent. Ms. Baugh's rent was alleged to be $1,390 plus costs. And she was working on getting some assistance from DHS and perhaps an employer. I thought she did speak last time with Mr. Fleeman in a private breakout room.
And Your
Mr.
Honor-
Robles, I'll put you in a waiting room. Here today is Casey Strong, Esquire, of the Strong, Fleeman and Bradshaw firm. And she's willing to speak with you privately, Ms. Baugh, and see where we are at this point. So let me set up a breakout room. All right, let me bring her back. How are we doing?
It's gonna be a conditional dismissal. I just wanted to make sure she was okay with the updated numbers.
All right. According to Ms. Strong, she's willing to submit a conditional order of dismissal. Ms. Strong, what would the terms be?
Thank you, Your Honor. The terms, as I discussed with Ms. Baugh, is the case would be conditionally dismissed as long as she paid rent in the amount of $150, court costs of $183.49, for a total of $333.49 on or before January 8th, 2026. And that is only reflective of her rent due through December. We discussed it in the breakout room. That does not include January, which will accrue as January accrues and not be part of this case.
Ms. Baugh, apparently you got some money or got some of that money you talked about, because it looks like you made a large amount, $1,200 or so. So that leaves just $150 for December plus the court costs. You agree to pay that by January 8th. Do you understand if you don't pay it, they could petition to reopen the case and ask for a writ of eviction? Did she explain that?
Yes, I did.
Ms. Strong, I'm not sure how able you are to send me an order
I have the order
forthwith.
prepared. I would just like to inquire from Ms. Bao on the record if I have her permission to sign her name to this document, which reflects all of the numbers I just placed on the record.
Yes, you do.
Thank you.
All right, if you email that to us, I'll provide a copy to Ms. Baugh before she leaves.
Thank you. We will get that email
All right,
right
so
over.
for now, the case is being conditionally dismissed, won't show up as a writ of eviction or even a landlord tenant judgment, as long as you pay that. She made a very good point that January's rent will be due January 1st. That's separate and apart from this. But you made a great big dent on this, so you've done quite a bit considering it was over the Christmas holiday as well. All right, if you go out to the counter, as soon as I get that, I'll sign it and I'll provide a copy to you so you can have it when you leave.
Thank you.
Do you have any questions?
No, sir.
All right, thank you.
Thank you, Your Honor.
Good morning, good afternoon, Mr. Robles. This
Good morning,
is
sir.
Discover Bank versus Michael Robles. File number is 25748GC. The plaintiff sued for damages in the amount of $8,996.85 plus cost and interest. A judgment entered in this case by summary disposition on September 22nd. There was no material issue of fact and no defense had been stated. $9,149.14 was the judgment. The plaintiff filed a petition for installment payments to pay at $50 per month. $50 per month on a $9,000 debt would generally not be acceptable, and that's not acceptable to the plaintiff. Did you get Meg's order yet? I mean, Casey's order yet?
I'm waiting.
All right. Good afternoon, Ms. Bauer.
Good afternoon, Judge.
Capital One filed an objection to your request for installment payments, but they aren't here. At that point, we without interest, it would take 15.5 years to pay it off. The plaintiff is asking for not less than $600 a month, which obviously you can't pay. But they aren't here to argue about it. $50 a month, they ain't gonna get it on a $9,000 debt. Now, Mr. Robles, if you don't have any money, you don't have any money. But if you are employed, they can garnish your wages. I'm gonna let the clock tick, yes, a little bit and see whether someone shows up. Have you talked to anybody from Discover Bank?
Yes, sir, I have. So Discover Bank is no longer in business. I have been trying to set up installment payments through them. Unfortunately, the payments that I'm able to afford, they don't want to accept. And I did reach out to the plaintiff's lawyer. They did say the same thing. I can't reach out to Discover anymore because Discover isn't an entity. But
yes.
I do have installment payments through Capital One already through my other credit cards. I am employed, but I'm a single father. And the reason for my predicament is my financial needs change. I ended up getting a divorce and then had to leave another job. So currently I only work one job. I am on government assistance and stuff. I don't deny the debt. I do want to pay it, but I just need something that I can afford.
Well, one thing I'd ask you to light in one spot. You're making me dizzy. You're walking all over the place.
Oh, I'm sorry.
That's just disconcerting.
Oh, I'm sorry. I get a little anxious.
All right, thank you.
You're welcome, sir.
Well, they're asking for $600 a month, which obviously you can't afford. Where are you employed?
LAD Incorporated.
At what corporation?
LADD.
Okay. What do they do?
It stands for Living Alternative for the Developmentally Disabled.
Okay. And is that a part-time job?
No, it's my full-time job. And they did start garnishing my wages on December 10th. They garnish, and they also garnish on December 24th.
Yeah, they asked to be excused from this, so I don't think they're going to show up. $50 isn't enough. $600 is too much. For you, $300 is too much. I'm going to order you pay installment payments of $150 per month, starting February 15th of 26. By the 15th of each month. I'm going to make this subject to review in 1 year.
Okay. Your Honor, they started garnishing my wages already. I was wondering if there was a possibility.
This will stop the garnishment.
Okay.
That should not have occurred. All right. I will process this forthwith to stop the garnishment. What is garnished will be applied to the debt. They can still file a garnishment of your tax refund. And I've made it for 12 months rather than 6 months. So $150 a month has to be better than what you're paying now.
Yes, sir.
And it's still not very much on a debt of this size, but you have to have enough money to eat. All right, that's my order. I'll send you a copy of it. Are you still at the East Chicago Road address?
Yes, sir.
All right, we'll send a copy of that forthwith.
Okay.
All right, you're good to go, sir. Do you have any other questions?
Yes, does the garnishment halt immediately or does it take a few weeks?
It should halt as soon as we get this order out there, which is why we need to get it out. This will forestall a garnishment of your wages.
Okay.
All right. You're good to go.
Thank you, sir. May you have a blessed day.
Thank you. Elaine, I know that Michelle isn't here and we're at the holiday, but we need to get that out sooner rather than later for his sake. The title of case originally was August Crimmins versus Melinda Wilson. That matter was set aside and defendant was allowed to file a co-complaint providing service on Dominique Hirschberger. They were able to secure service and they indicated that once they received a judgment against Dominique Hirschberger, they would be willing to dismiss the case against Melinda Wilson. I see that you've provided me with a default judgment to enter against Mr. Hirschberger. You were able to secure service on the defendant?
Yes, there are.
Judge, there should also be a stipulated dismissal in there
Yeah.
against Ms. Wilson with my signature on it.
Yeah, I filed that at the same time that I filed a default judgment, so court should have both copies.
Yes, I do. Thank you. Meg Bauer has joined us. She's here as well. All right, Mr. Hirschberger is not here. He lives in Indiana.
She had an order in there. I just didn't know when you wanted to start.
I did another order. There's another order.
There's another one in
They
there?
provided one. I used theirs. That was on top of that one. There's an order. All right, let me make some notes here. I'm going to enter the default as to Dominique Dwayne Hirschberger in the amount of $10,572.32, $308 in cost, an attorney fee of $75 for total default judgment of $10,955.32. Collecting on that may be another matter altogether. And per plaintiff and defendant, sign a consent order of dismissal regarding Melinda Wilson. That order states, no judgment shall enter against Ms. Melinda Wilson. This is a final order as to Ms. Wilson only and resolves the last pending claim between Dr. Krimis and Ms. Wilson. However, it does not close the case. The case may continue to proceed against defendant Dominique Hirschberger. And that pretty much says it. And there's a default as to Mr. Hirschberger. So it did take us a while to get here, and you do have a default judgment. Again, collecting any money may be more difficult, but this case is over. Mr. Borsman, I think you made about 5 trips here, but everybody had to work for the common goal here. All right. Anything else we need to place on the record from either of you?
No, Your Honor. Thank you.
All right, thank you. Are you actually working today?
You know, I'm here, so I am working, but
Well, I guess this counts for working, but we're back after the holiday today and tomorrow and Friday. All right, I'll see you next time. Thank you.
hey, thank you.
Mike, thanks a lot.
Thank you, Meg.
Glad we worked that out.
Yep.
All right, it's good for your client, not so good for the other guy who trashed the place, but. All right, next we have Bobby Joe Bainbridge, but this matter isn't set until 2:15, so I may need to let the clock tick for a minute. We just placed on the record a default judgment against Dominique Hirschberg in the amount of $10,935.32 with attorney Michael Borisma for the plaintiff and Meg Bauer for the co-defendant Melinda Wilson. Default judgment in it against Mr. Hirschberger, and a consent dismissal was filed as to Melinda Wilson. As we discussed, the judgment entered collecting on it may be difficult to do. Schumann versus Greg Meyer. In that case, we did have a default judgment on behalf of Mr. Schumann on September 29th in the amount of $2,922.51. Plaintiff did a subpoena for Mr. Meyer to appear here today to provide information on his ability to pay on this debt. He was personally served with a notice to appear, and he has failed to appear.
Yeah.
Is anyone here on behalf of Greg Meyer? Mr. Schumann, have you had any contact with him?
No, I have not since the date before the initial hearing. During those 30 days, he made no effort to contact me or the landlord of the park about the issue.
He's in contempt of court because he has failed to appear pursuant to a lawfully personally served subpoena. We don't have a debtor's prison. You can't go to jail for not paying a debt. However, when you get a subpoena, it's a court order. It's not a birthday party invitation. And when you ignore it, you're in contempt. You can go to jail for that. I'll do a bench warrant for Greg Meyer. Bond is $1,000 cash only. May be applied to the debt. If he's served with the bench warrant, he posts $1,000 bond, it'll be applied to the debt, and we'll schedule the discovery hearing. If he's arrested and he can't post a bond, he'll sit in jail until such time we can have a hearing.
Okay.
So I want you to contact the clerks. This is small claims court. You got some work to do yourself to do the bench warrant. But if anybody knows Greg Meyer of Cato Lane, Sturgis, who are doing business as, I can't remember the name of his company, needs to contact the court, or he's subject to being arrested shortly in lieu of $1,000 cash only bond.
All right.
All right.
I would have to call the clerks about the bench warrant.
Yes, that would be my suggestion.
All right.
All right.